1704 CR 2022-001242.
Freddie Kay on behalf of the state. For the record, the next of kin in the 2021 and the victim in the 2022 are appearing virtually.
Good morning, Your Honor. Pamela Hicks, Advisory Counsel on behalf of Ms. Daybell, and Robert Abernathy is out of the office today.
Okay. You want to announce?
Lori Daybell, on
Thank you.
behalf of myself.
All right, we have a number of things to get through this morning. The first thing I want to address is there's been multiple media requests. I don't know if there's a representative of the media that can address this, but my question is if there's a single pool camera, is there some sort of agreement or cooperation between other media outlets to use a single camera?
Your Honor, if I may, Matthew Kelly, I represent Court TV, and our understanding is that, yes, there is a pool arrangement, and Court TV has asked to be the pool for the trials in this matter. I believe that that request is pending with the PIO. Regardless, the media that are interested in camera coverage do have a pool arrangement.
Okay. I know that there was, I don't know if it was Court TV or another outlet requested multiple cameras and a still camera. I'm inclined to just allow a single camera. Do you want to speak to that?
Yes, Your Honor. Court TV would prefer to have two of its own cameras. One of its own cameras is perfectly fine. Court TV's equipment is actually smaller than the camera we have here today and can be operated remotely, so it is much more unobtrusive. Court TV also has, in the past, used the feed from one of the cameras here for the webcasting of hearings for its purposes as well. Court TV will position its camera so that jurors are not in the field of view and would not use any of these cameras that have a view of the jurors.
All right, thank you. Is there anyone else here from the media that wants to be heard? I don't hear any. State want to take a position?
No, Your Honor.
All right, I know the defendant filed an objection. I've read your objection. Do you have anything you want to add to that?
Yeah, Your Honor, I'd just like to add some case law to that. Shepard versus Maxwell, 337 U.S. The United States Supreme Court, Mr. Justice Clark, held that failure of the state judge in murder prosecution to protect defendant from inherently prejudicial publicity, which saturated the community to control disruptive influences in courtroom, deprived the defendant of a fair trial consistent with due process. So that and Arizona versus Cheney, which was the defendant is entitled to fair and impartial trial when publicity pervades court proceedings to the extent that the proceedings were prejudiced to the defendant. So obviously you read my objection, so I just wanted to add those on the record.
Okay.
Thank you.
Your prior attorneys had filed a series of objections to media coverage media being allowed in the courtroom, and I made a prior ruling that was filed back September 4th, which was fairly comprehensive. I am inclined to allow one pool camera. I'll issue an order with more detailed findings later today or tomorrow. But essentially, there won't be any media coverage during the jury selection process, and I'll put the reasons for that in the order. So that's, again, I'll issue a more detailed order later today or tomorrow. All right.
Your Honor, there's also the issue of whether Court TV will be allowed to live stream the trial, in other words, broadcast online in real time. Court TV would prefer to do that.
Are you able to, are they able to do a 1 or 2 minute delay?
Certainly, we can certainly do that. I just want to inform Your Honor, however, that when we share the footage with the pool, we can't delay that footage. So your order would need to require that all media receiving the feed delay it by, however long you wish to delay it.
And the camera, the pool camera would be simultaneously distributing that feed to whatever media requests it?
That's correct. We have the capability to distribute to up to 30 or 40 different media outlets, so we have plenty of bandwidth to do so.
It's prejudicial and it's going to be his fault.
All right. Thank you.
Thank you.
All right. Let's get down to business on some of the,
Your Honor,
yeah.
could I just add that we want to make sure that the cameras aren't going to be zooming in at any level to get to our notes and the things that are going to be on the table. I also previously, what has happened before is that they just have the camera on my face the entire trial. So I think when the judge is speaking, the judge needs to be on the camera. When the state is speaking, they need to be on camera. If we can add that to the order, I think it
All
would
right,
be
well, my
correct.
draft already includes that there'll be no zooming in on council table, anything on council table, or anything being handled, notes or that sort of thing being handled by any of the parties or the attorneys. As far as what they focus on, they'll be limited to focusing on the parties, myself, the witness, depending on the witness. I need to ask the state about that in a second, but they won't be allowed to broadcast any image of any juror. While I'm on that subject, let me ask the state, are you seeking any sort of protective order when a named victim testifies?
Not at this time, Your Honor.
Will you let me know if that changes?
Yes, I will.
Do you have, do you have the names of your designated victim or victim representatives that might be testifying?
Kay Woodcock is a statutory legal victim and will be testifying.
Is that the only one?
At this time, yes.
Okay,
For this trial, I should say.
for this trial, okay. Let me ask this, are the parties ready to proceed around March 31st or April 1st?
Yes.
Yes, Your Honor.
All right, let me ask the state next. Earlier during these proceedings in past hearings, you indicated you thought the state's case in chief would take 2 weeks. You requested yesterday to screen for 6 weeks.
Your Honor, I did say 2 to 3 weeks.
Okay,
But I did say that while we had a defense attorney on and not Ms. Vallow herself. I am familiar with other pro per trials where generally the timelines are in excess of those with a defense attorney assigned. So in order to ensure that we aren't asking a jury later to stay longer than we pre-screen them, I believe it would be appropriate to screen them for 6 weeks.
so now that you're gearing up for trial and maybe you have a better idea, how long do you think your case in chief would take with a normal amount of cross? I know that's hard to estimate.
And again, I would say 2 to 3 weeks.
3 weeks?
That would be at the outset of it.
Okay.
Probably, yeah, 2 to 3 weeks.
Okay. Let me ask advisory council, if we do an questionnaire, would you be assisting Ms. Daybell with your laptop in going through the answers that are received?
Yes, Your Honor. I mean, assuming we do all of that, because a lot of times the courts send us back to our office to go through that. So if we do that here, then yes, of course, she's welcome to use our laptops.
All right. My plan is we can do jury selection in the South Court Tower 5C. I know that the state has requested that the entire trial be held there. We can't do it. We can do jury selection there. I can give you rooms here for your victims and witnesses as need be that are outside this courtroom that we'll have. We can have them stream in if you want, depending on, I guess, who the witness is or who's back there.
And obviously, Your Honor, I don't know if the public will be attending this or not. This also is a little different in that even in the mornings, the jury is going to be potentially out here while the court is having morning calendar. If there's media out there as well, I'm just trying to protect the integrity of the trial by ensuring that the public, the media, are not interacting with witnesses at any time while they're out there. It's difficult when it's a very small hallway and very limited rooms to put them in. Obviously, I need a room for the victims that's separate from any witnesses.
Well, we have on this floor 6 rooms? 5 or 6 rooms throughout. We have 3 right behind this courtroom, and we can utilize them as need be to ensure that there's no improper contact between media or the public in general and any victims or witnesses. We can also ensure that the jurors don't have contact. If that means we bring them up in a separate elevator and have them assemble somewhere else, we can accomplish that. So my plan will be to do an e-questionnaire, remote questionnaire for the first 200 jurors. That questionnaire, I need to get a final joint pretrial statement with the list of witnesses to include the names of witnesses in that, but I'd like to send out a draft to everyone by the end of this week. Let me bring up my calendar. We would probably send that out to the first 200 jurors around next Thursday, March 20th. Yeah.
Because of the way they send this, the first day they can send it out the 24th.
Oh, I guess they can't send it out.
So you can do from the 24th to the morning of the 27th.
Okay, so we can send out that the 24th to the 27th, meaning it would be cut off on the 27th. The answers to those questionnaires would be emailed to the parties. That would give the parties the 28th, 29th, 30th, and 31st to go through those answers. We would meet on the morning of the 1st, discuss who needs to be let go based on those answers. Also on the morning of the 1st, a number of walk-in jurors that for whatever reason don't fill out the questionnaire in advance would come in to the jury room, the jury assembly room that morning and fill out the questionnaire. So that morning we'd also deal with those walk-in answers as best we can. Oh, that's right. I back up. The initial answers for the remote, we're gonna meet on the 31st. Let those people go. Whoever we don't let go will be told to report on the afternoon of the 1st. On the afternoon of the 1st, we'll be dealing with the walk-ins that come in the morning of the 1st. And the people that we haven't let go the afternoon of the 1st, that will be in person voir dire as needed. If we need to, which I anticipate we probably will, we'll do another 200 jurors on the 2nd. And if need be, we have another 100 jurors on the 3rd.
That next set of 200, that wouldn't be a remote question?
They
That'd
don't
be
have
regular.
a capability to do it remote, so we may have to, what'll happen is on the 1st, all those people, after they give their answers, will be randomized, the list will be re-randomized. As we proceed through the 2nd, those people get added onto the bottom of the list. So as soon as we get 12 jurors that qualify, that everyone's happy with, that don't have issues, plus probably 3 or 4 alternates. So as soon as we get to about 15 or 16, we're pretty much done with jury selection. So we don't have to necessarily question all 200 of those people. We can do panels of 20 or something like that. I anticipate losing quite a large number of people just based on prior media coverage and people already having some sort of opinion about the case. I normally wouldn't include a defendant's name in the e-questionnaire that goes out remotely, but on this case, I'm inclined to, just because that's what we want to know. We want to know if people have heard about the defendant and whether or not they've heard about, or if they've formed an opinion about her or this case prior to that. Does anyone have an issue with that, State?
No, Your Honor, I think that that's a good idea. That's going to be at least one of the initial reasons to strike a lot of jurors.
My only issue with it, Your Honor, is that it could be bad both ways, right? If you put the name in there, if you don't put the name in there. It's been my experience that people will say they haven't heard when they know who that really is, and there's people that will want to be on this jury just for this purpose.
Well,
It's going to be complicated.
all the research indicates that these e-questionnaires, people are more likely to give honest, candid answers than if they're in a group of people and they feel sort of that peer pressure of what's a good answer and what's a bad answer. Your name's going to come up sooner or later, so I would prefer to just get it out in front of the potential jurors to begin with. My e-questionnaire is going to be fairly basic. It's going to focus on qualifications, the charges, the witnesses, and then obviously whether they have an opinion about you or this case. For the people that make it past that level, we'll question them more thoroughly in person.
And like you were saying, as far as group kind of voir dire, in my experience, we went through 1,900 jurors in my last trial, so it would be good to do individual voir dire if we can, than group voir dire, because they learn things just in the voir dire, and it disqualifies a lot of jurors.
I'm not opposed to that, but that's going to be sort of a day of play it by ear sort of situation, whether we do small panels or just go a single person. If we go single person, our jury selection could extend into the next week. But if we're able to seat a jury, I would expect opening statements on April 7th, somewhere around there. Does the state indicated, I have it, there was just one day in April that you wanted to go a half day?
Correct, Your Honor, the 24th.
All right. When can you file some sort of pretrial statement that sets forth all your potential witnesses and a statement of the facts?
Probably by Thursday.
All right.
Work.
Does the state anticipate any presentation of autopsy photos or crime scene photos? In other words, I'm trying to gauge, I would usually put in a question about jurors may be required to view evidence that shows wounds or that sort of thing. Is there anyone that's unwilling to look at this type of evidence?
Yes, Your Honor, we will have both, obviously, with self-defense trajectory, and those injuries are very relevant.
Okay, so I will include a question about that type of evidence. Sometimes jurors don't want to look at that type of evidence, so. All right, any questions or concerns about our jury selection, the proposed trial dates from the state?
No, Your Honor.
Just so I have it clear, Your Honor, we're going to start on the 31st with jury selection, is that
We'll
correct?
be meeting on the 31st,
Okay.
and then actual dealing with in-person jurors on the 1st, 2nd, 3rd.
Okay.
Robert and I.
Let me ask advisory council, are there any dates that advisory council would need to be dark?
I am fine for April. I didn't hear back from Robert. I would think.
Please
I'll be
let
fine
us
for-
know, because in that e-questionnaire, I'm going to put in a proposed schedule. I don't know that I'm going to screen for a full 6 weeks based on the state's anticipated presentation, maybe 5 weeks. So let us know the schedule into the first week or two of May.
As soon as I get an answer from him, I'll email your judicial assistant.
All right.
And one more time, Your Honor, so the remote question is going out on March 24th. All answers have to be back by the 27th, so we will get them on the 27th, or,
You'll either get them late the 27th or first thing the 28th.
I have
Okay.
in the morning, late in the morning of the 27th.
Oh, okay.
okay.
So I'll put it-
You should get them some point on the 27th.
Just so we can plan, because it sounds like we'll just go out to Estrella and go through these.
Yeah, they're closing it at like 8 AM on the 27th.
You'll have to have a internet connection.
Yeah,
out
we
there.
can use
Okay.
our laptops out there,
Okay.
because you want to be ready to discuss everything on March 31st.
Yeah, and if the parties have an obvious, there's some jurors that are going to be obvious that need to be let go. If you're ready for that, that's always helpful. I know it's a little bit more difficult with pro per defendant in consulting like that. All right, let me get to,
So we'll come out on Friday and go through the questionnaire.
We don't get any questions on that.
all right, the defendant had filed 2 separate motions for specific discovery. The first dealt with communication between the assigned deputy county attorney and law enforcement agencies. I've read and the second one was, well, let's deal with the first one. I've read the response from the state. Basically, your response is you have disclosed all those communications. There are no other communications.
Correct, Your Honor.
All right. So let me ask the defendant,
Yeah, we received 6 email communications, and they were in a short time frame, not the full time frame. And it seems to me that in the last email ends in kind of a question that was probably answered, and then there's like no more communication. So it doesn't make sense that there's no more. We asked for all of them if they could be provided to us. We don't understand why they're not being provided to us, and what the state is possibly hiding at this point, and they can't just turn it over so that we can go through them. It's been, long over a month since we filed that motion, so we would just like them to please turn over whatever they have left.
all right, and I'll ask the deputy county attorney, I imagine some communications are by phone, so in other words, we're not captured.
Correct, Your Honor.
All right. Based on the state's avowal, I don't know, I can't tell them to turn over something they say they don't have, so. I'll find that the state, based on their avowal, and officers of the court have complied with the request. The second one is a little more, I wanted to get clarification on. That was defendant's request for video interviews, but it seemed like based on the state's response that there was some confusion about what was a interview recorded in an interrogation room situation versus a body cam. Did the state's response provide clarification to you?
No. So the body cams were turned over, and they're in like 12-minute increments. There's like 4 different body cams. This was a full 2-hour video that was released by Gilbert Police to the public, and it's online. So I would like that video of the interrogation room, the full 2-hour one, to be turned over to the defense.
All right, so do you know what that is?
Your Honor, based upon the defendant's reply, she's requesting a video interview from the 31st. Those are on body cam and were turned over to the defense. We have requested everything from, I think that one was from actually the Gilbert Police Department. A lot of these overlap. So I am not sure what the defendant is.
Who was the person being interviewed, and you said the 2-hour interrogation that Gilbert released?
So it's myself and my daughter, Tylee Ryan, and Melanie Gibb.
And is that in an interrogation type room?
Yeah, it was at the Gilbert Police Station, and I didn't realize we were being filmed that whole time. I didn't know we were being filmed, but we were being filmed in that room.
And are you familiar with a video in a room?
Yes, that's what we have disclosed, is an interview of, it is
And you're saying you don't have it?
defendant, her daughter, and another.
And you're saying you haven't gotten that?
They have given 4 about 12-minute body cam videos of the policemen's body cams that were in the room with us, and they go in and out of the room at different times. So there's different body cams. They're all mixed up. It's not the full entire one, and the full entire, my understanding is that the full entire 2-hour interrogation room video from the ceiling is available online, but I don't have it in Discovery.
That's what I'm trying to clarify. So did the state disclose not a body cam, but an interrogation from up in the corner of a room vantage point?
I mean, we disclosed a lot. Let me see if I can find out. You did? Yes, my paralegal is present here as well, and she has advised that we did. Your Honor, we disclosed over,
Can your
Where is
paralegal
it?
provide a Bates number or something so that maybe the defense just has overlooked it?
let me see if we can find the actual
Maybe the discovery notice. date.
discovery letter.
Okay.
Your Honor, all we do have is the 4 body cam. We can ask again and see if they have a overall.
Are you getting this, have you seen this, or someone told you that there's this video?
My mitigator showed me part of that video, yes, with my previous team. That's how I know about it, otherwise I wouldn't know about it. She said, do you know this is online? I didn't have any idea.
And you're sure it's the Gilbert PD on that date?
Correct.
All right, I'll ask the state to follow up with Gilbert on that.
We will, Your Honor.
There, if that is out there, obviously it should have been disclosed. All right, remind me to follow up on that next time we are together. Next, I have a motion limine, 2 motions in limine, one regarding Alex Cox statements and one regarding Tylee Ryan's statements. All right, so let me ask the defendant, generally any hearsay is defined as any out-of-court statement offered for the truth of the matter asserted. The state is referencing what are definitely out-of-court statements. Obviously, there's some exceptions to the hearsay rule, and there are other things that are characterized as non-hearsay. So how do you think, let's first talk about Alex Cox. How do you think the statements fit into your, either one of those exceptions or non-hearsay?
I feel like the state is blanketing that whole thing, and obviously it's like a case-by-case basis, right, on these statements. So there is the police interview of Alex Cox that I do not think falls under hearsay.
Why not?
Why does it not fall under hearsay?
Yeah.
Because we're not using it for the truth of the matter asserted. We're using it in corroboration of the circumstances. Everyone came in and told their same story that corroborates different facts in there, not for the whole truth of the matter.
Aren't you arguing that what he said was true?
I can't say whether another person says that it's true or not, but I'm saying what he said and what my daughter said and what I said in those 3 police interviews determined what the police said, how the police acted, what they did after that, their next steps, how they treated the entire case like it was self-defense. All of those are relevant to the defense that it was self-defense. So, yes, I think they're for that purpose. But I also think that Alex's statements also have a lot of the exceptions apply. 803, 804, there's a lot of exceptions that also apply to some of his statements and not all of his statements.
Such as what? Which statements do you think they apply
So
to?
Specifically his statements made on body cam to police in the driveway, specifically his.
I don't know what the statements are, so that's what I'm asking. What specific statements do you think are allowed to come in under the rules of evidence?
I think under 8031, the present sense impression is his statements made to police officers at the house.
A present sense impression is where you're actually observing something and you're talking about it as you see it happen. So, isn't he saying, again, I don't know what the statements are, but is he saying what happened prior? Or is he saying
Yes,
something
prior.
that he's, okay,
Correct,
so it's not a
prior.
present sense impression.
Okay.
What else?
Then I think it falls under 8032, excited utterance. He was under the stress of the whole situation when he made those statements.
What was his demeanor when he made those statements?
Upset.
What's the specific statement?
I shot my brother-in-law in self-defense. I got hit in the head with a bat. There was an altercation. I don't know what all the statements are, but
How long after the incident did he make these statements?
immediately after, as far as I know.
Well, immediately to some people means 2 seconds, to other people it means 30 minutes. Tell me what immediately means to you.
As soon as the police arrived.
I don't know did they arrive 30 minutes after the incident? 10 minutes, an hour?
I was not there. I do not know what time they arrived.
All right. So you're asserting excited utterance, some of these statements come in, what else?
8033, the mental, emotional, and physical condition, because it shows his state of mind, which was scared at the time.
Any others?
Yes. 8035B, the recorded recollection. I know that in the state's reply to my response, they did not think that 805 applied because A, B, and C, but I did not see an and after A, so my assumption was that B and C, since there's an and after B, were what needed to be put together. So B was made or adopted by this witness when the matter was fresh in the witness's memory and accurately reflects the witness's knowledge. So I felt like 803B, the recorded recollection of his police interview and the body cam footage applies under that exception.
All right. Generally, 8035 is a recorded recollection, meaning it's something they wrote down, or maybe they recorded their voice saying something. Let me ask the state to respond. We're just talking about the Alex Cox statements.
Your Honor,
Maybe I should start with,
Yeah.
does the state intend on introducing any statements from Alex Cox?
Your Honor, I haven't decided if we will at this point. I can say with 100% certainty, we will not be admitting his interview by police that was done at after 10 o'clock in the morning. We don't,
Are you referencing what time he was interviewed versus the time of the incident?
let me say it this way. So the state has laid out in its motion the timeline. So that is actually in our motion. We show that when
8:30 a.m.
is when the
roughly.
911 call was made. So we have soon after that, the police arrived and there's body cam video from that interview. Then Alex Cox is later brought to the police station and there is a in-depth interview with detectives at a little after 10 o'clock in the morning.
So you may or may not be attempting to introduce statements at or around the time that the police responded?
Correct, Your Honor. If we do, those would be brought in as co-conspirator statements against a party interest. So obviously the state can bring in statements that are hearsay against a party.
Right. But I guess, is the state intending on introducing any statements of Tylee?
No, Your Honor. Kylie made no statements at the scene other than giving her general biographical information on body cam. Her entire statements were made at the police station, again, after 10 in the morning.
All right. So on your response as it relates to Tylee, you say, again, present sense impression. I don't think it's a present sense impression. You also argue excited utterance. What else?
8033, which is mental, emotional, and physical condition with the same thing, her state of mind, then being scared. And also 8043, statement against interest. They use that statement in the indictment where Tylee says that Charles says, if you hit me with that bat, you're going to jail. That's the part where she's nervous in her interview saying she's scared to tell the police that she's the one that brought in the bat. So state of mind and the statement against interest both apply to Tylee's
All right.
police interview.
All right. Anything else? Does the state want to be heard further on that?
Your Honor, the only further thing I think that the state will bring in is that obviously the defendant has been found guilty of killing both Tylee, other individuals, but in this case, the defendant cannot benefit from killing a witness and then later try to bring in their statements for their benefit. So in addition to none of her statements being admissible under the rules of evidence, as any of the exceptions that the defendant has done, we also believe that it would be improper for her to be allowed to bring them in under that theory.
In other words, there's been a judicial finding that the reason Tylee's unavailable as a witness is because of the defendant's actions.
Correct, Your Honor. There has been a jury trial and she has been convicted of that.
All right. All right, the court is, on a preliminary basis, precluding references to Tylee Ryan's statements, any statement made by Tylee Ryan. If there's some reason where a door might be open to any of those statements coming in, the defendant's requested to make a request outside the presence of the jury regarding that, and we'll deal with that outside the presence of the jury. On Alex Cox, I think that's probably going to be more of a statement by statement basis. but I'm skeptical of any statements coming in hours after the initial police response. I think we'll deal with what statements may or may not come in when the police first arrived on scene and or the 911 at the time that they're attempted to be introduced. All right, I also received yesterday state's notice of disclosure and request for disclosure. Did you get a copy of that?
No,
You haven't seen that yet?
no.
I'm sorry, the,
State's notice of disclosure and request for disclosure. I didn't realize, it was actually filed in January, so you should have seen that. I misspoke when I said I got it yesterday. It was filed January 16th. Have you seen that?
I'm looking it up.
What are we,
Dates
I
disclosure.
think the court may have ruled on that one, Your Honor.
Well, I don't think I ruled on, at the very end, you're requesting, she submit to fingerprints, palm print, footprint.
Oh, that's, okay. I think that was fired, yes, significantly. So that would be to tie her to any of her,
Is that for other conviction purposes?
correct, yes.
All right. And when did you want to do that?
If we are going to be here on the 18th, we can take them then.
I don't know that we need to be here on the 18th.
And obviously, I was unaware we were going to set this because we set it
Right.
just recently, so. I don't know if we can keep that on just to take that.
Okay, what about the state, you requested copies of any recorded statements made during interviews conducted outside of your presence. Is there any of those, were there any interviews conducted by you or your team? Of
So
any
far?
Were there any interviews conducted of any witnesses out by you or your team that you're aware of?
So far, not that I'm aware of.
All right. Do you plan on calling any experts to testify?
We do plan on calling one expert.
Who's that? Has it been disclosed to the state?
We are, yes, we're working on that today as an addendum to the
Who's that?
witness list that, Lonnie Dworkin.
All right. That's your investigator?
No, my investigator, Jeff White.
Oh.
That's the expert.
What kind of expert is Lonnie Dworkin?
Phone and digital.
I think I remember his name. Are you aware of that?
No, Your Honor.
All right, expert reports and disclosures are due 30 days before trial generally under the rules, so if you're planning on using that witness, you need to get that disclosed right away, and I may have to take that up depending on what the state's position is. But
Your
at this
Honor,
point,
that-
it's technically late.
May be another reason to be here on the 18th. Obviously, if that's disclosed this week, we can potentially address that issue on the 18th.
All right. Let me ask the defendant, do you have a position on the taking of prints and photographs? Generally, identification type things are permitted over any defendant objections. So do you have a record you want to make on that?
Not really.
All right, I don't see any
For
reason
what
why.
purpose? I don't understand.
In the event that you're convicted, it may be used to prove other convictions. That reminds me, is the state planning on proceeding in the second trial regardless of what happens in the first trial?
I believe so, yes, Your Honor.
And how much time would you need between the conclusion of the first trial and the start of the second trial?
Your Honor, I would say at least 30 days, since we do need to actually subpoena out-of-state witnesses for the second trial.
I'm wondering if it wouldn't benefit everyone to go ahead and set that, a provisional second trial date now.
That's fine, Your Honor.
May 11th is still my last day.
Is that second trial,
Right.
how long do you think it would take the state to
Probably
present?
about 3 weeks as well.
Similar?
I'm not gonna argue. Your Honor, I'd like to remind the court that the last day is May 11th.
Well, I'll probably exclude some time based on the fact that you can't do 2 trials at once.
The state could combine the trials and do 2 trials at once, but they don't want to do 2 trials at once, so it really violates my speedy trial rights if they do not give me a speedy trial by May 11th for both cases. Not to mention that they did combine all the discovery into one case. They didn't give me 2 different separate discoveries for 2 different cases, which would be much more convenient considering the voluminous amount of discovery that they piled onto us.
Does the state want to do, combine both cases?
Your Honor, if the court gave us a little time to work it out and the defendant wants to join them, I mean, obviously,
I don't know that,
the normal defense attorney, and I don't mean that in any way, normally they would be
Derogatory?
severed.
severed because you
Due
don't
to-
want one jury to know about the other
Correct.
2 separate charges and have a harmful rub-off effect of the evidence in one case affecting the evidence in another case.
Correct, Your Honor. That's why they were filed separately. But if the defendant wants them together, the state would have to request this be pushed back slightly so that we could then get all the witnesses for that trial together, since they were not subpoenaed for this trial. But if that's what the defendant wants to join them, and she understands that prejudice, and that she's then going to be waiving that prejudice with that, then the state is certainly willing to do that. But we would then have to request to have that trial, or this trial date moved back to allow us to get the other witnesses lined up.
That's not what I was saying, to combine them. I'm just saying, give me my second trial by May 11th. So
Right.
the court can figure that out.
All right, well, I'm going to waive some time on that second trial over the defendant's objection. Primarily, again, the defendant can't try both cases at the same time. Secondly, I'm not sure how much actual prejudice there is with a time violation in the sense that you wouldn't be released from custody anyway. And thirdly, the rule for time violations under Rule 8, I think it's 8.6 is that any violation should be a dismissal without prejudice unless there's an actual prejudice shown, in which case the state could just refile the charge. Regardless, I think some time is warranted to be excluded because primarily you can't try 2 cases at once. What if we set a start date for May 12th? I realize that's could potentially be a quick turnaround, but again, I don't think this case is going to take 6 weeks.
Your Honor,
We can adjust that as necessary.
I, again, am going to ask for a longer time. I believe this will go through the beginning of May, and to have the state try to get those witnesses lined up and subpoenaed while in trial, I don't believe is.
Well, if I push it out any further, the parties need to be aware that I won't be trying the case. I don't think I would be anyway. I'm rotating at the end of June. And given some of the trainings I have to attend in June, I don't think we could get it done.
Well, both parties could send out subpoenas now for that second date for May 12th, correct?
Well, that's assuming we're done by about May 1st, probably, in this case, the first case.
And then, Your Honor, I did indicate that the state needs to be dark in May, the 21st, 22nd, and 23rd.
You said 21, 22, 23.
Correct.
Of May?
And I would need to be dark the 19th, 20th, and 21st as well, so.
So given that we would be dark that entire week anyways, it really doesn't make a whole lot of sense to.
All right, sorry to interrupt. Let me speak with the criminal presiding judge about scheduling the second trial. We can discuss it on the 18th. Let's keep the 18th, but let's move it to later in the morning. Actually, let's move it up. All we're going to do is discuss a couple matters, and then there's no reason for the fingerprinting and stuff to be broadcast or on video, so I'll prohibit that from being recorded or otherwise broadcast. So have your person here. Let's do that at 8:15 a.m. on March 18th. And then we'll also discuss whether the defense is disclosing Lonnie Dworkin as a witness and whether or not he has a report, expert report, prepared and disclosed at that time. I will have the questionnaire for you by then, so you can review it. Anything else we need to discuss that I've forgotten about from the state's perspective?
Your Honor, I showed two other motions that the defense filed that I did not see rulings on by the court. They were both motions to dismiss. One of them only related to the 2022 case, I think. No, I'm sorry. Both of them related to both.
What's the filing date?
January 14th for one of them was an 8.2 speedy trial one. And February 4th, which was an extradition rule 8.3.
February 4th? Okay, so the motion to dismiss CR 2022-001242 for lack of speedy trial, I ruled on January 24th.
Okay.
That minute entry was filed January 24th, and then the motion, was that the motion to dismiss CR 2021 and 001704 and the other for violation of Speedy Trial Act?
Correct.
That was ruled on February 25th, so last week,
Okay.
a week ago. Anything else from the state?
No, Your Honor.
Anything else from the defendant?
Yes, Your Honor, I have one kind of housekeeping matter that I wanted to ask you about. I know that MCSO has some security restraints, the things that I have to wear during trial, and
I meant to
I wanted
discuss
to ask about that as far as, am I going to be able to stand at the podium to talk to witnesses, to question my witnesses and to cross-examine? Or am I going to be able to move about with the leg thing and the shock vest and all that?
You're gonna stick to your table and you can go to the podium, okay?
Okay.
When you're giving your opening statement and closing argument, you'll stay by the podium.
Okay,
And if you need to hand a witness an exhibit, your advisory council will do that.
okay. Or my paralegal can do that
Or
too.
well, is your paralegal gonna be present here designated as your, I guess they can be present. I'd prefer advisory council to be the one that approaches witnesses if you need to hand an exhibit or something like that.
Okay, so I'm gonna be standing there, and if she's sitting here, she's gonna come get something from me and go walk it over to the witness and then come back?
Correct.
Just the logistics of it? Just
Yeah,
the-
and there'll be a table or a cart here that'll have all the exhibits on it within reach of the podium, so.
Okay.
Anything else?
Your Honor, do you use case lines for exhibits?
No.
Thank you.
I think they're still working out the bugs on that, so.
Do we need to have our exhibits in place?
All right, we'll see you at 8:15 on March 18.
So she can mark on.
Be at recess on this matter.
It's usually like a day or two.
All rise.